Welcome back to the deep dive. Today we're really digging into something that can feel a bit, well, slippery in contract law
Yeah,
consideration.
that's right.
Specifically, what happens when a promise seems totally dependent on one person's say-so, their satisfaction, their control? How do we tell a real promise from one that just evaporates? An illusory one.
Yeah, the illusory promise
So,
problem. It's
yeah.
fundamental. I mean, for a promise to count as consideration, you need to give something up, right? Suffer some kind of legal detriment.
Uh-huh.
But if your promise is basically, I'll do it if I feel like it, have you actually promised anything? Have you limited your future options at all?
Doesn't sound like it.
Exactly. So the initial thought is no detriment, no consideration, no contract. It's void.
Okay, so that's the problem. How do courts get around this? Because, tons of contracts have these kinds of conditions, right? Subject to financing, pending inspection.
Right. And that's where we get to the core idea for today. The implied covenant of good faith and fair dealing. It's sort of the hidden engine that makes these contracts work.
The hidden engine. I like that.
So the path today looks like this. First, we state the basic rule why these promises look illusory. Then we bring in this concept of implied good faith. And finally, we'll walk through some key cases, starting with the big one, to see how good faith actually rescues these contracts.
Perfect. So let's start with that baseline rule. What's the black letter law when a promise is conditioned entirely on what the promiser decides?
Well, the doctrine is pretty clear initially. A promise conditioned solely on an event within the promiser's, let's say, arbitrary control or personal satisfaction, risks being deemed illusory.
Risks being.
Yeah, because if I promise to buy your car, only if I decide I like the color tomorrow morning, and my liking the color is based purely on my whim,
Mm-hmm.
then I haven't actually bound myself to do anything. I can always just say, nope, don't like the color. No detriment suffered. So classically, that promise fails as consideration. The agreement would be void.
Okay, that makes sense in theory. But you mentioned real-world business deals, like big land sales. It feels like applying that rule super strictly could just blow up agreements the parties genuinely wanted, right?
That's exactly the tension. Courts recognize that. Parties often do intend to be bound, even with these subjective conditions. Voiding the whole deal seems, well, commercially unreasonable sometimes. It defeats the parties' expectations.
So they needed a way out.
They needed a way to honor the intent. And that's why they started implying terms. Instead of just reading the literal words, if I'm satisfied, they read in an implied promise.
Okay, let's see. This implied promise in action. You mentioned a key case. Let's dive into that one. Mezzanotte v. Freeland from '73. It involved selling the Daniel Boone complex. Sounds intriguing.
It does, doesn't it? And it's a perfect illustration.
Okay, let's analyze Mezzanotte v. Freeland. First, what are the legally dispositive facts?
Right. So the Mezzanottes, they're the buyers, agreed to buy this property complex from the Freelands. They put down a $5,000 deposit, standard good faith money. But here's the crucial part. The contract said the deal was contingent, or conditioned, upon the plaintiffs securing a second mortgage from North Carolina National Bank on terms satisfactory to them. That's the key phrase, satisfactory to them.
Ah, okay. Sounds like our problem condition.
Exactly. Now, what happened was the Mezzanottes actually couldn't get the loan from that specific bank, NCMB.
Oh, so the deal's off.
Well, wait. They immediately went out and got the necessary funds from other sources. They were ready, willing, and able to close. They tendered the down payment, the documents, everything.
So they found the money anyway.
Yes.
Yeah.
But the sellers, the Freelands, they refused to close. They pointed back to that original contingency clause.
What was their argument?
They argued the buyer's original promise was illusory because getting financing satisfactory to them meant the buyers could have just walked away for any reason, even if NCMB had offered a loan. They claimed there was no initial consideration.
Okay, I see the fight now. And what was the core legal issue the court had to decide?
The central issue was, did that satisfactory to them financing clause make the buyer's promise to purchase illusory, meaning it lacked consideration and the contract was unenforceable from the start?
Got it. So how did the court save the contract? What rule did they apply?
They leaned heavily on contract treatises, specifically Corbin. The rule they applied was this. A promise conditioned on an event within the promiser's control is not illusory if the promiser also impliedly promises to make a reasonable effort to cause the event to happen, or, critically here, to use good faith and honest judgment in deciding if the condition like satisfactory financing has been met.
So it's not just about the condition itself, but about the implied effort or good faith in evaluating it.
Precisely. That implied promise, the promise to try honestly, to judge fairly, Not just on a whim that is the legal detriment. That's the consideration.
That feels like the hidden engine you mentioned. Okay, so what was the court's analysis then? How did this implied promise apply to the Mezzanottes?
The court reasoned that the parties obviously intended a real contract, a mutual deal. Therefore, the law implied that the Mezzanottes had promised to make an honest, good faith effort to get financing.
Not just sit back and maybe decide later.
Right. They couldn't just reject financing out of personal whim. If they were to reject financing terms as unsatisfactory, it had to be for a genuine reason, something consistent with reasonable business standards, not just because they changed their mind about the deal.
And the fact they went and got money elsewhere.
That demonstrated their good faith. They cried NCMB, it didn't work, but they didn't just quit. They diligently found other funding to meet their end of the bargain. That fulfilled their implied obligation to make a good faith effort.
Makes sense. And the conclusion?
The conclusion was that the contract was valid and enforceable. The buyer's promise wasn't illusory because it included that implied duty of good faith effort. So the trial court's decision ordering specific performance, forcing the sale, and awarding damages was upheld.
Okay, that clarifies how good faith stops the whim problem. Let's try a hypothetical to really cement this, something memorable.
All right, let's hear it.
Suppose you're a curator, okay, and you contract to buy an incredibly rare, let's say, the preserved, mummified hand of a notorious 17th century pirate. Maybe it's rumored to be cursed, adds to the value. Big price tag.
Okay, a pirate hand. Got it. Visceral enough.
The contract has this clause. Purchase is contingent upon buyer being satisfied with the specimen's aesthetic appeal in buyer's sole discretion. Now, you go to inspect. The hand is, objectively, perfectly preserved, museum quality. But you suddenly decide, nah, you want out. You tell the seller, you know what, I just don't like the shade of yellowing on the knuckles. It's unsettlingly beige. I only collect cheerfully colored pirate relics. Is your promise illusory? Can you walk away?
Okay, unsettlingly beige. Based on Mezzanotte, your promise is not illusory, and you likely cannot walk away just like that.
Even with sole discretion, written right there.
Even then, the court would imply that your satisfaction isn't based on pure personal arbitrary whim, especially not one unrelated to the actual subject matter, the quality of a preserved artifact. Sole discretion regarding aesthetic appeal would be interpreted through the lens of good faith and honest judgment as applied to a preserved pirate hand. Meaning, your judgment has to relate to standards relevant to that kind of object preservation quality, historical appearance, maybe even the expected level of gothicness for a cursed pirate hand.
But not my sudden preference for cheerful pirate hands.
Exactly. That sounds like a capricious rejection, an excuse unrelated to the actual quality or nature of the item contracted for. It's likely a breach of your implied duty of good faith. If the hand meets reasonable standards for such a specimen, you're probably bound to buy it, unsettling beige knuckles and all.
Okay, so the implied duty really does put guardrails on even seemingly absolute discretion. That's crucial. Now, Mezzanotte didn't come out of nowhere. You mentioned it relied on earlier cases. Let's quickly run through a few using that FIREX structure again, just to see the consistency.
Sure. Seeing the pattern helped solidify the rule.
Let's start with J. Dreher Corp. v. Delco Appliance Corp. In that one, a manufacturer, Delco, reserved the right to reject any order submitted by its dealer. Sounds pretty one-sided. What was the rule the court applied there?
The court, with Judge Learned handwriting, found there was consideration. The key was implying a promise. Delco, despite reserving the right to reject, implicitly promised to exercise an honest judgment when reviewing the orders. They couldn't just arbitrarily refuse orders in bad faith. That duty of honest judgment was the consideration.
Okay, honest judgment for commercial decisions. Next, Commercial Credit Com v. Insular Motor Corp. Here, the promise was to buy only acceptable time sales obligations, like financing paper, from a car dealer. What was the conclusion on whether acceptable made it illusory?
The conclusion was, nope, not illusory. The contract was binding. The court explicitly said, acceptable does not mean acceptable by whim.
Ah, same theme.
Exactly. It meant acceptable according to the usual business standards for that type of financial paper. It set an objective benchmark, preventing arbitrary refusal. That made the promise real.
All right, then there's Richard Bruce & Co. This involved an underwriter who had, quote, absolute discretion to terminate a deal if market conditions became undesirable. That sounds even stronger than satisfactory. How did the court limit absolute discretion?
You'd think absolute means absolute, right? But the court said even that term is implicitly limited by the requirements of fair dealing and good faith, a reasonable discretion.
Wow.
So the underwriter couldn't just claim undesirable market conditions if, say, they just got a better offer elsewhere. Their decision had to be grounded in a good faith assessment of actual market realities relevant to that type of deal. That limitation made the contract enforceable.
Okay, good faith even trumps absolute discretion. Now, back to real estate, like Mezzanotte. What about Sheldon Sims Covey Wilder? Buyer needed to get a specific $24,000 loan for the deal to go through. What kind of effort did the court say the buyer had to make?
The court held the contract was valid because the buyer had an implied duty to make a diligent effort to actually get the loan. They couldn't just sit back and do nothing or make a half-hearted attempt and then claim the condition wasn't met. The duty to try diligently was the consideration.
Diligent effort for external conditions. Got it. And one more, Mate v. Nopper. Another real estate deal, this one contingent on getting leases from tenants that were satisfactory to the purchaser. What was the core implied promise there?
Very similar to Mezzanotte. The court found an implied promise that the purchaser would exercise good faith in judging whether the leases were satisfactory. It wasn't just about personal taste. It involved evaluating the leases based on reasonable commercial standards for that kind of property investment. That implied promise of good faith judgment provided the necessary consideration.
Okay, so across all these different scenarios, judging orders, financing paper, market conditions, getting loans, evaluating leases, this implied duty of good faith, whether it's honest judgment or diligent effort, consistently pops up to save the contract.
That's the common thread. It prevents promises conditioned on satisfaction or control from being purely illusory.
This is incredibly helpful. Now, for our listeners, especially maybe students facing an exam or someone drafting a contract, can we boil this down? Can you synthesize these rules into like a step-by-step diagnostic checklist to spot and analyze this issue?
Absolutely. Think of this as your quick issue spotting tool for conditional promises and potential illusory problems. Here's a 4-step approach.
Okay.
Step 1, identify the condition. Look at the contract language. Is one party's obligation contingent on their own satisfaction, judgment, or control over some event?
Find the potential escape hatch.
Exactly. Step 2, check for whim. Does the language, read literally, seem to allow that party to just walk away based on pure personal arbitrary preference? Does it look like they haven't really committed to anything? If yes, then move to step 3.
Okay.
Step 3, apply the implied covenant. This is the crucial step. Ask, does the law imply a duty here? Usually it will be either A, honest judgment, typically for things involving commercial evaluation like market conditions or accepting orders, or B, diligent effort, good faith, usually for trying to make an external event happen like getting financing or permits or evaluating something like leases based on reasonable standards.
So figure out which type of good faith applies.
Right. And finally, step 4, determine detriment. If the law does imply that promise of honest judgment or diligent effort, good faith, then that implied promise itself is the legal detriment.
The consideration is found in the duty to act properly.
Precisely. And if that implied promise exists, then the main promise it supports is not illusory. It's backed by consideration, and the contract is enforceable, even if the original language sounded very discretionary.
That's a really clear framework. Identify the condition, check for whim, apply the implied covenant, honest judgment, or diligent effort, good faith, and determine detriment based on that implied duty.
That's the diagnostic. It cuts through the initial appearance of illusoriness.
So the big takeaway seems to be, even when a contract looks like it gives you total freedom to decide based on your satisfaction, the law usually steps in and says, not so fast. You have to act in good faith. You can't just use a satisfaction clause as a get-out-of-jail-free card based on a whim. There needs to be a reasonable, justifiable basis related to the contract's subject matter.
That's the essence of it. The implied promise of good faith is, in many ways, the glue that holds these common commercial agreements together.
It really changes how you read those clauses.
It does. And it leads to a perhaps deeper question about contract law itself. Well, if this implied promise of good faith is so consistently used to find consideration in these potentially tricky situations, you have to wonder, is the traditional, sometimes very technical doctrine of consideration fading a bit in importance? Is it becoming less about finding a specific bargain for detriment and more about simply asking, did these parties intend to be bound? And if they did, will we use the tool of implied good faith to enforce that intention?
So is good faith basically becoming the real test and consideration, just the historical label we put on it when we find that intent?
It's something to think about, isn't it? How much work is consideration doing on its own anymore versus how much is being done by this powerful implied duty of good faith?
A very provocative thought indeed. Something for all of us to chew on next time we encounter one of these satisfaction guaranteed clauses. Thanks for navigating us through that complex terrain.
My pleasure. It was a good dive.